Hello, everybody.
Good afternoon.
Afternoon, Judge.
Afternoon.
How are you, Your Honor?
I am good, thank you.
Okay.
We have a box marked Chris. Is that Chris McGowan?
It is, Your Honor. Good afternoon. I'm in New Orleans on vacation with my wife. It's her 40th birthday this week, so I'm struggling to. I call in at the request of Mr. Powell, so that is the situation. If you're good with it,
There's no picture, and I'm okay with that if everyone else is.
Fine with me, Judge.
I'm fine with that, Your Honor.
Okay, and then we have a box marked Amy Miller. I assume that's your client, Mr. Powell.
That's correct, Judge.
Okay. And a box Caleb Boone.
I don't have my video on, Judge. That's all right.
Well, it's okay with me if it's okay with everybody else.
Yes.
Yep, no objection.
Okay. This is in the District Court of Brooks County, Kansas, case number 15 CV 29. It is Denise Roan versus Brad and Amy Miller. May I have an announcement of appearances, please?
Your Honor, I'm Denise Roney. I'm pro se.
Your Honor, may it please the court, plaintiff Justin Miller, I think is not appearing because he had dental surgery recently, but appears through court-appointed counsel, retained counsel, Craig Urick, Oakley, Kansas.
Your Honor, Chris McGowan appears on behalf of Mark Miller, plaintiff.
Your Honor, I'm Jeanette Miller. I'm pro se.
Okay, that's the petitioners.
Please the court, Your Honor, the defendants appear personally via Zoom and through counsel Todd Powell.
May it please the court, Caleb Boone appears pro se, Your Honor, as the intervener. I should say as
Right.
one of the interveners.
Jim Angel on behalf of the Trust Company of Kansas, Your Honor.
Okay, we are on for a couple of motions filed by two of our pro se petitioners. Is there anything else we'll need to deal with today that counsel are aware of?
Your Honor, I had asked for a hearing to update the court and the parties on the status of things on my client's end, given the Supreme Court's denial of the petition for review. So I wanted to provide an update and make sure we're all on the same page.
Okay, you want to do that first?
Sure, if that's okay with the court.
Go ahead.
Okay, Judge. The defendants have a contract to sell some of their real estate. That is scheduled to close on March 25th, although that may happen sooner. We got the title commitment today, and it has a couple requirements relating to this case, requiring lien releases that were filed, or releases of liens that were filed in Osborne County. Basically, this court's judgments were recorded in Osborne County. And so the requirement is to release those liens. I have communicated with Mr. Angel and provided him the information on the sale and on the title commitment. And so I guess I just, A, wanted to notify everybody that that is going on. And B, I guess, again, make sure we're all on the same page about how we move forward. There will be enough proceeds of the sale to satisfy the court's judgment, both as to the reimbursement of the trust and the attorney's fees. And so as far as I'm concerned, if all this goes as planned within the month, this matter should be completely resolved. Judge, we will need probably the cooperation of all the parties, probably in the form of signing lien releases to be held by the title company pending closing, so that good title to this property can be conveyed. So I guess we would ask, I don't have any motion to put before the court right now, but I guess, Judge, I would just like that if there were a need to enforce any orders or make anyone cooperate with the requirements to get this land sold, that Your Honor would at least be receptive to hearing those things. So Judge, that's basically all I had, and I'll let, if Mr. Angel has anything to add from his standpoint, I'll let him do that.
Mr. Angel.
Yeah, thank you, Your Honor. So this is the best way to get the orders of this court carried out. And how the process will work for the non-attorneys involved here is we will all sign the same release. That release will be held with the title company. Once the title company verifies that there is good funds, and that we're going to be paid everything that we're owed, then the title company will be tasked to file those releases. But those releases, so they'll have to be signed before the closing, but they won't see the light of day if the closing, unless the closing occurs and everyone is paid in full, meaning all the specific orders of the court, the money to the trust, the money to the various attorneys, all those orders, all that will have to be paid before it can be released. And from my understanding, there's enough funds to do it. I've looked at the real estate contracts. And so, I mean, this, as Mr. Powell said, is correct. If this is done correctly and it closes the way it's supposed to close, which I don't have any reason to believe it will not, then we should be a spot at the end of the month where the orders of the court has been fulfilled, and then the trust on the Trust Company of Kansas on their end can start the process of distributing those assets.
Mr. Urick. You're muted.
Thank you, Your Honor. Yes, Your Honor, we would have no objection to any of that. I think in talking to my client and my understanding of some of the talk with other counsel, I think there may be some motions after everything's paid up. There may be some interest amongst the heirs or the beneficiaries, I should say, in terms of possibly dissolving the trust. But I think that's something that can be handled later.
Yeah, that's not an issue before the court at this time. Mr. McGowan.
Yes, Your Honor. No objection to any of that here.
Okay. Miss Denise Roney.
I have no objection, but I'd like to know which section of land that Brad's going to be selling. It's kind of sad to me. Which piece of land is he selling?
Well, I think you can, if you want, you can call Mr. Powell and talk to him about that.
Okay,
Okay.
yeah.
Given the status, Miss Roney, you had filed a pro se motion on February 26th
Yes.
to release the stay. Now that this has been explained to you, do you want to proceed with your motion or withdraw your motion?
Yes, let's proceed with the motion to release the stay of the trust.
Well, how would you propose doing that prior to the sale?
Well, how much is in the trust? Can Jim tell us exactly what it is in the trust as of the date?
I'm not sure I understand your question.
Well,
Right now, the what's in the trust, and I don't know exactly how much it is. It wouldn't be much different than what I had sent you in the letter, Denise. What's in the trust is oil runs that have been paid into the trust pursuant to the court order. We don't have any of the 1.7 million plus interest because we're going to collect that from the proceeds of the sale.
yeah, I understand that, but what is in it? I don't have anything. I haven't had anything since like the last, I mean, of the total amount that's in the trust today. I haven't received anything just in the last month, like an accounting.
I assume that
I think Jeanette has it, but I didn't get anything just this month yet. I think she's got it. Jeanette, do you have something that shows?
You're muted, Jeanette.
Am I still muted, Judge?
Oh, now you're live.
Well, if I may speak a second, I have the same question that Denise had. There seems to be some difficulty at one time on all the accountings, and they have provided accountings from the trust fund, company for all these months, but it's always been reflected in a cash value. And it seemed to me on the accounting, it has now been changed to a cash equivalent. And I've been told they invested the money in annuities. So I never gave permission for any investment out of my part of my 20% of the distribution. So I wanted that to be clarified.
I never gave permission to invest my 20%. At
And
all.
I'm worried about what's gonna happen with the 1.7. I've never gave million, if it goes into a trust, I've never gave any permission to invest any money. Thank you.
Well, the court's order was for the trust to pay out as it came in, but they have to wait until after everything now clears the appellate court, which it sounds like it has. And then the sale will pay everything back in, and then they'll be in a position to pay out to each of the other 4 siblings.
Yes, I think the last accounting I got, there's approximately 220,000 is what's showing. But I don't want any of mine invested ever, Jim, ever. So there should be about that in there. That would go 5 ways. And then the 1.7 million plus interest, it goes 4 ways. And I never want any invested. It goes straight to my account and my bank's ready.
And I'm sorry, Judge, if I can speak again, I'm not gonna object to the sale of the land. I'm going to go ahead and approve that. But I do need some clarification on the accounting of where if it's cash value or cash equivalent in the trust fund, please. Thank you.
And I do have on my mother's testimonial trust that no creditors can ever place a lien on, file a judgment against, or garnish the trust assets that do belong to the beneficiaries. They are the owners of the Walker Miller lease and the Houghton lease. And there's a couple of other leases that are missing, like the Green lease in Graham County is missing. My mother was the lease hound on that, and we need to check in on that. Maxine Green, I remember her. My mother had a 30-second overriding interest on that green lease. We need to find it. And then my grandma Rock, her Arrington lease is missing.
Right.
So,
Miss Roney, I don't mean to cut you off, but you're getting a little far afield of what we're doing here.
okay, I understand, Judge, but there are some leases that are missing. Maybe Todd can find them. But yeah, no investing.
Okay.
That's all.
So as far as the request for any distribution at this point, Mr. Angel.
I'll speak to I can speak to my clients about that. Certainly there would be some money that they could distribute now. I mean, hopefully within the next 20 days, we'll be in a position to get that money in, and then shortly thereafter. I haven't heard any indication from the Trust Company of Kansas other than when this is all done, transferring everything out. Transferring everything out, paying whatever ancillary bills they need to pay, and being done with the case.
You understand, Ms. Roney?
Yes, I understand.
Okay, any further clarification you need at this time?
No, I think within 20 days, like Jim said, that's fine.
Okay.
Yeah.
Well, and Ms. Roney, the closing is on the 25th. That's 20 days from now. So
Yeah.
it won't be instantaneously after the closing, but sometime shortly thereafter in the next week or so.
Yeah.
It'll take some time to process it. It can't be instantaneous.
Yeah, I understand. Yes.
And Ms. Jeanette Miller, you filed a motion pro se December 1st. For a
I'm sorry, Judge.
distribution. You filed a pro se motion for a distribution on December 1st.
Correct, sir.
Okay. Do you need any further argument on your motion?
I would like to clarify that I have asked the trust fund the trust company, to make distributions. I received a letter from them saying as soon as the mandate got to the courthouse, they would then start distributions. I'm worried a little bit. I want Justin and Mark to also be concerned about the 1.7 million going into the account, making sure that's gonna go to all 4 ways to the beneficiaries. That does not go 5 ways. So I have no other thing to say about it. Thank you, Judge.
Good.
So, Your Honor, what I intend to do is I intend to, the very first part of next week, circulate releases, and everybody will sign the same release. The Trust Company of Kansas will sign the same release as all the other parties will sign. It's all going to look identical or virtually identical because there's a little bit different judgments. With the idea, again, I want to make sure it's clear, those will be held in escrow by the title company. Those will not be filed if there's not enough money to make sure everybody's paid in full. And us doing it this way by using the releases and allowing the court this to go through is the quickest way to do it by far. If we have any issues leading up to closing, then the closing will fall through. There'll have to be another motion filed with the court. There'll have to be more. It will push it out months, potentially. So everybody working together to get this paid is the right thing to do so that we can get the court's order followed and go on down the road.
Judge, the only other thing I would add, if I may, is just, again, maybe a standby thing for the court that just in case something else comes up, there's some other requirement, or, you know, there's another order from the court. Again, the purpose of this hearing was just to make the court aware that this was going on, and hopefully that the court will, if need be receptive to any motions or anything. Again, if a release doesn't get signed, that we can follow up on that, and basically anything that needs to be done that needs the court's attention, that we can do that to get this matter closed.
Yeah, please, the court, this is Caleb Boone. I have a question, if that's all right.
You are my next person to call on, Mr. Boone.
All right, Your Honor, when I listened to Jim talking about everyone filing those releases, I assume what he means by that is all the beneficiaries within his bailiwick. Is that correct? Because I'm a separate party, and I've already discussed with Todd Powell my releases. Is that right, Jim? Just you're referring to the trust beneficiaries, right?
Yeah, yes, Mr. Boone. I mean, but obviously, if there's a hang up in your release, the deal doesn't get done.
But
So
I've already worked all that out with Todd.
Yeah.
But
Yeah.
you were not
Yeah,
referring
no.
to me as being one of those, everyone that you were talking about.
Right.
I understand.
I was just saying that generally. Obviously, I can't speak for you, Caleb.
No, I appreciate that. I realize that. And I agree with the general concept. I just wanted to make sure about the specific forms you had.
Yeah, I've been tasked, the court tasked the trust company with collecting this debt, and that's exactly what I'm doing.
Yes, of course.
I guess one point of clarification, though, based on Mr. Boone's statement is I mean, I think it remains to be seen of kind of thinking out loud here. Obviously, the parties will need to sign releases, but also any other judgment creditors, and there are 3 beyond the trust. Mark Miller, Caleb Boone, and Craig Urich. And so either with these releases or some other document, the title company is going to have to be assured that we have those releases and or satisfactions in place in order to clear title. So Caleb, I guess I can't answer the question in terms of whether you're going to be asked to sign this release, but I do believe you'll be asked to sign something. And again, that would be a matter that I would hope we could all cooperate on. And if not, it would be a matter we'd have to come back and bring back to the court.
May it please the court, I understand what Todd just said. And so the way that I would see it mechanically, maybe because we've got 2 groups of people, if you will, one, Jim's group, and the other one, the remainder, the other three people, which would be, if you will, Todd, your group, we're all going to be signing either a satisfaction of judgment or a lien release, but I think a satisfaction of judgment would be of the equivalent effect as any releases that Jim is collecting. Wouldn't that be right? And then those would all be combined together, and then you'd submit all yours that you got from the three of us, along with, at the same time, to the title company, as Jim would be submitting all of his documents. Would that be right?
I generally agree with that, again, with the caveat of you know, the title company is going to have the last say on what their requirements are.
Sure, sure.
But short of that, I don't disagree with the concept.
Well, the reason I mentioned that was because I wanted to be respectful to Jim so that we all do the same things at the same time, just like Jim said. I agree with that. We've got the three of us on your side, so to speak, Todd, and then Jim's got all those beneficiaries on his side. That would all just come together at the same time, and then physically those would be either sent in by you to the title company and Jim to the title company at the same time or something like that, right?
I believe so from where I sit, yes.
All right, well, thank you for letting me say that. Thank you, Your Honor. I just wanted to make sure I fully understood exactly what Jim was envisioning. I respect it.
And Mr. Powell, you've got the necessary releases from Mr. Boone, Mr. Urick, and Mr. McGowan,
Do I have them?
or were you preparing those?
I will prepare them, Judge. Yes.
Okay. And I think you spoke about Mark Miller, but I think that's actually Mr. McGowan.
Well, we'll
far as
probably need to
fees-
clarify
as far
that
as-
one way or the other.
As far as the fees,
I had thought that was an award to Mark directly, but Mr. McGowan and I can work that out, I think.
okay.
I think
Anything else?
Sure.
Anything else, Mr. McGowan? You're muted, Mr. McGowan.
Sorry about that. No, Your Honor, I will clarify. I think what everybody's talking about, I think there's two parties actually. I think it's Mark and me. Mine for my fees, and then I think there was some award to Ross for his work prior. I think that's what was confusing everybody, just to be clear. So yeah, I'll work with Todd and get all that worked out. Shouldn't be an issue.
Right, it was awarded to Mark to reimburse
Mm-hmm.
what had been paid to Ross.
That's right. And then I had a subsequent amount that wasn't huge, but so yeah, I'll work both of those things out with him. Yep, that's not a problem.
Okay. So
And
some-
actually, I throw one more question just to make sure we're clear. Because I mean, so the rest of everybody was on their own as far as appeals goes, right? As far as attorney fees for appeals goes, right? Just to be clear, I think that me and Todd had discussed that, but I just want to make sure we get that on the record. Everybody was kind of on their own appeals fee on their fees, correct?
I'm not sure what you mean by everybody was quote on their own, end quote.
We're not doing attorney's fees. My concern is not, no one has to come back for attorney's fees, right? I mean, does that make sense for the appeal and stuff? That was all individual, correct?
No one's asked it for the court to do anything other than let each party pay their own.
That's what I was making sure of. That's it, Your Honor. Thanks.
As far as I'm aware, there's no motions in front of the court. I'm looking at the docket. I don't see any motions.
No, we didn't want to. I just wanted to clarify. Mr. Yerk and I discussed and we couldn't remember, and I just wanted to clarify. It's my understanding that's what you had issued, and I talked to Todd and he agreed. I just want to make sure I wasn't missing anything.
Judge, if I may, I do believe there was discussion earlier that that the attorney fee awards were as of the date of the award, and that anything that happened beyond then was not included in attorney's fees. It wasn't an open ticket, so to speak, to come back and say, well, we've now incurred X thousands of dollars more. We need to add that on. That was a final judgment.
Right.
And so, yeah, that's my understanding.
That was my understanding as well.
I do, Judge, I have the order pulled up, and I know you're pressed for time, Judge, and I don't want to belabor this, but I also don't want to, this is kind of a sensitive situation. I don't want to leave any doors open that we're going to need to have any issues on. So the court's award, and again, forgive me, but I'm going to paraphrase here a little bit. Plaintiff Mark Miller's attorney, Ross Wickman, submitted attorney's fees of $76.25. His attorney, Chris McGowan, submitted fees in the amount of $1,600. There were some that already been paid. Therefore, the court awards these fees and the total amount to be paid by defendants to plaintiff Mark Miller for his attorney's fees through June 24th, 2022. So I just wanted to point that out.
Okay.
We're good. That works for us. Yep, that works.
Are we gonna have another hearing before all this is settled or after it's settled?
The court is not anticipating another hearing, and as
Okay.
long as all this goes through, I don't think you need another hearing.
Okay,
Okay?
So then what your order was today, then the trust company is to be the receiver of the money, and then that will be distributed as you've ordered to the beneficiaries, correct? Right?
Well, it's all going to be paid back into the trust. And then the trustee will distribute it in accordance with the court order. And then the future incoming oil renditions will be distributed per the court order. And
Thank
that, the future ones, after everything is paid off, the future ones, I believe, are just 20% to each sibling.
Thank you.
So, and Miss Roney and Miss Miller, just for the purposes of the record, I'm gonna deny your pro se motions because I don't want to mess up any of the accounting and anything that's happening.
I
You're so
understand.
close to getting this done. Let's get it done.
yeah, I understand. Yes,
Okay,
I
so-
agree.
let's get this done here. Hopefully by about the 5th of April or even before that, you'll have received a substantial check.
Okay, thank you, Judge.
Thank
Thank you for everything.
Mr. Urich, you were either adjusting your glass or you had glasses or had a question.
No, Your Honor, nothing more from me.
Okay. Anything further from anyone for the record?
No,
I don't believe so, Judge.
No,
Yeah.
thank you.
Mr. Powell, to the extent you believe we need a journal entry from today, I will entrust you to prepare that.
Okay, I will, Judge. Thank you.
Okay. Okay, thank you all.
thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.
Thank you so much for being here. Be safe, be well, sleep sweet, and much love.